Chapter 6, Organizational Change, Part 4. In this last PowerPoint lecture of this chapter, we're going to focus on one particular law that was written and passed in the 1990s that gives the federal government more power to force change. So when we covered Madison and Chicago, these were attempts to change police departments, but voluntarily. These were really coming from within the police department, and they were wanting to change. But what happens if you have a police department that just won't change? Maybe it's beset by corruption or scandal or other kinds of problems. They just don't have the will, or they don't have the capacity, or they don't have both to actually bring about the changes that are necessary. Well, in the 1990s, in response to the Rodney King riots, and problems with the LA police, and then we identified problems elsewhere across the United States, Congress passed a law that is popularly known as the Rodney King Law. And so it's a civil law, so it doesn't bring criminal penalties with it, but it's 34 U.S.C. 12601. And then again, it's popularly known as the Rodney King Law. And what this law does, it's a really short law, it's only 2 paragraphs long, but it contains a lot of powers for the federal government, because what it really does is it allows the federal government to bring a lawsuit that will force a change in the culture of the police, and to take really drastic measures to do so. And this law is based on the federal racketeering law known as RICO that is used against organized crime and other kinds of criminal organizations. So again, what it's really trying to do is not get so much at the individual officer who's corrupt or is a bad police officer, but it's really targeting the department as a whole, or at least units of the department. And so what is unlawful under the Rodney King Law? Well, and you can read along here. It shall be unlawful for any governmental authority or any agent thereof, etc., etc., etc. We're going to skip over some of this. To engage in a pattern or practice of conduct by law enforcement officers, skipping over a little bit more, that deprives persons of rights, privileges, or immunities secured or protected by the Constitution or laws of the United States. So in essence, as we apply it to police, the Rodney King Law makes it unlawful for police officers to engage in a pattern or practice of depriving people of their rights, privileges, or immunities under federal law. So this isn't a one-time incident. This isn't, even though it's named after Rodney King, it's not just a Rodney King episode where maybe only one motorist is beaten. But this is where maybe there's a pattern or practice of doing it, or of racially profiling, or of unlawful interrogations, or intimidating people to prevent them from complaining about the police, or a whole measure of things. Okay, so it's really directed at that. And remember, it's a civil law, so we're not bringing criminal actions, we're bringing civil actions against the police department, or maybe units within the police department. Who can bring this action? Only the Attorney General of the United States. And what I mean is the Attorney General's office. So it doesn't have to be the actual Attorney General. Okay, it doesn't have to be that only one person can bring this. But what we mean is the Attorney General of the Department of Justice in the United States. So the Attorney General is the head of the Department of Justice. The Department of Justice is the only entity that can bring a lawsuit under 34 U.S.C. 12601. So no one else can. A private individual can't bring a lawsuit under this particular law. A state attorney general or a state district attorney or anyone else like that. Only the federal, so only the United States Attorney General. And we'll see that the primary responsibility for enforcing this is given to a particular unit within the Department of Justice. But the Attorney General can seek equitable and declaratory relief to eliminate the pattern or practice. Okay, so we'll talk about equitable and declaratory relief in just a second. So as I said, only the U.S. Attorney General is authorized to sue. The chief unit that's within the Department of Justice that's responsible for enforcing this law is the Civil Rights Division. So the Civil Rights Division of the U.S. Department of Justice is who's going to bring one of these lawsuits. They have to show, again, that there's a pattern or practice of depriving people of their rights. So if it's just a one-time incident, then, and you don't have any suspicion that it's recurring, that it's a pattern, it's a practice, it's a common thing for this department, if you don't have that proof, then you can't bring this lawsuit. You have to be able to prove a pattern or practice of depriving people of their rights. The U.S. Attorney General can sue only for equitable and declaratory relief. Usually when someone sues, brings a civil lawsuit, they're suing for monetary damages. And so when you have a car accident and someone wrecks into your car and they were the ones who were negligent, and you sue them, you're suing them for the damages to your car. You're trying to get money for it. Or maybe you had some injuries. You're trying to get your medical expenses paid. That's usually what you're suing for in civil court. That's not allowed under this law. The Attorney General can't sue for any money. What the Attorney General can sue for is equitable and declaratory relief. Equitable relief means practically any kind of order from a court other than an order for money. So you can, for instance, under the Rodney King law, the U.S. Attorney General can come in and say to a judge, can argue to a judge, in order to end this pattern or practice, once we've proven it, we want the chief of police removed. And the judge may order that as part of the equitable relief. Or maybe we want new training implemented, and the judge will order that as equitable relief. Or maybe they'll say we want this police department to stop using the chokehold. And so the judge will order them to stop doing something. So the equitable relief may require somebody to do something, or it may require them to stop doing something. But basically you can ask for almost anything as long as you can convince a judge that it's reasonably necessary to end the problem. And so that's how the judge will determine if the request for equitable relief is fair or not. Declaratory relief means that you're suing to ask the judge to declare certain things, to make a finding on certain things. So maybe it's, we want you to find that the State College Police Department has engaged in racial profiling. And so there may be equitable relief attached to that. You may say, okay, we want you to have them keep records of every traffic stop, and they have to report it to a federal officer. Okay, that's the equitable relief. But the declaratory relief is a finding that they have been found liable and found, in essence, guilty of racial profiling or whatever. And you may say, well, who cares if they make that finding or not? Well, there may be private litigants out there, private individuals who are going to sue under other laws. So some of the people who were racially profiled may, after the federal government is finished with their Rodney King lawsuit, these other people may want to bring a lawsuit for damages, for money. And so they don't have to reprove everything if it's already been proven that this department was guilty of racial profiling. They're just going to have to prove that they were one of the victims, or likely one of the victims of this racial profiling. And so declaratory relief can be important because it can be the mechanism for other people to really save a lot of time on suing the department. And oftentimes the police departments will settle these Rodney King cases just to avoid that declaratory relief, just to avoid being labeled as a department that has deprived people of their rights. Because if that declaratory relief isn't stated, isn't given, if the judge doesn't have to make that determination, then that group of private individuals are going to have to prove it in their lawsuit. They can't rely on that declaratory statement by that judge in the federal government's Rodney King case. So equitable relief is basically asking for the performance or the cessation of certain things, and declaratory relief is a finding of certain facts. The first police department sued under the Rodney King law was actually Pittsburgh. There was a case that actually didn't involve the Pittsburgh Police Department. It involved one of the many police departments that are in the Pittsburgh area, the Braddock Police Department. But there was a former Pittsburgh Steeler whose cousin was stopped during a traffic stop, or was stopped for a traffic violation, and the police during the traffic stop struggled with him and eventually killed him. And so that brought a lot of publicity, especially when this is a cousin of a Steeler. He was a current Steeler at the time, now retired Steeler, obviously. But that brought a lot of attention, and soon there was a lot of criticism of the Pittsburgh Police Department. And in 1997, Pittsburgh became the first police department to be sued under the Rodney King law. They eventually, and pretty quickly, the mayor's office settled the case. They decided not to go to trial. The arguments were that the Pittsburgh Police Department was using various minor offenses to discourage people from complaining against the police. So, for instance, the complaint alleged that the Pittsburgh Police Department was threatening people with false arrest. They were sometimes arresting people for being drunk in public, even though they knew the people weren't drunk. They arrested people for resisting arrest, even when they didn't resist arrest. When there was any suspicion that this person might complain against the police or file a complaint against the police, maybe they had observed the police violating somebody else's rights, and they threatened to complain against them. And so the police, what was alleged in the complaint was that the Pittsburgh police would counter somebody who maybe they thought was going to complain against them. And so they would say to that person, "You're drunk." And the person would say, "I haven't had anything to drink." And the police would say, "Oh yeah, you're drunk. We're taking you downtown." They would take them downtown, put them in the drunk tank for a while. And then after a short amount of time, they would say, "Okay, I guess you're right. You're not drunk. You can go now." Well, it was almost impossible to appeal that treatment. Everybody knew what was going on. They were intimidating this person to discourage them from complaining against the police. But because they were released without being fully charged, then these kinds of cases escaped any kind of review. So the Department of Justice latched onto this and said the police are depriving people of their civil rights. They have the right to complain. There were some other parts of the complaint too, but you're depriving them there's a pattern of practice of depriving people of their rights, and we're bringing this lawsuit against you. Well, and again, the mayor's department eventually decided to settle the case over the objections of the police department. The police department said, "We're not doing these things, and if we are, it's just a few isolated officers. It's not the department. You're going to make us look like we're a corrupt police department." But nonetheless, the mayor settled, and so the police department, well, they were allowed to maintain and keep their leadership. So the police chief didn't have to resign, wasn't forced out, anything like that. But they had to implement new training, sensitivity training, racial sensitivity training. They had to report every time they made an arrest for public drunkenness, for resisting arrest, for disorderly conduct, for these relatively minor kinds of offenses that they'd been using to threaten people they had to report to a federal officer, a court-appointed officer, who would monitor. And they monitored other practices of the police. So for 4 years, the Pittsburgh Police Department had to report to this federal officer who was appointed by the federal courts. And finally, in 2001, the federal officer went to the court and said that, in his opinion, the oversight could be lifted, that the police in Pittsburgh were now in compliance, and that there was no need for federal oversight anymore. Well, there were several after Pittsburgh. There were several other police departments, a lot in the Pittsburgh area, and that were eventually also sued under this law, and they pretty much all settled their cases like Pittsburgh did. And so there was some momentum gaining in the last years of the Clinton administration to bring these kinds of cases against other bigger departments, but so both Clinton and then later Obama actually did bring lawsuits, and they were going to bring, there was an investigation underway into the New York City Police Department, but under George Bush II, everything kind of came to a crashing halt when 9/11 hit. Then it wasn't seen as so popular to actually bring these cases against police departments, especially the New York City Police Department. You just suffered a great tragedy, and we're not going to it's politically just not going to happen that you're going to bring a lawsuit at that time against them. So the Rodney King law kind of went on the back shelf until Obama came back into office, and then Obama slowly started to re-implement these lawsuits. But Trump has pretty much, as I think most people would probably expect, has not given any backing to these kinds of lawsuits. So I don't think, until we see a president who wants to more vigorously enforce this law, even though these seem like really effective ways to bring about changes in police department when they didn't want to, I don't think we're going to see many of these lawsuits as long as Trump remains in office.